All-important hearing. The gay marriage case hearing has begun in the Supreme Court. The centre asking the Supreme Court to hear its objections first. The centre arguing that petition is not maintainable. The Solicitor General Tushar Mehta has said that this is the domain of the legislature and that this is a policy issue. Now remember, an affidavit was filed by the centre in which they said that this is an elitist concept. Neelashish now joining us for more. Harish Nair is inside the courtroom who's sending us updates. Yes, Neelashish.
Well, yes, as of now the hearing has begun and Solicitor General Tushar Mehta is saying that the subject is a matter of the concurrent list and we cannot rule out the possibility of one state agreeing to it and another being against it. In this case, if the states are not being joined, the petitions will not be maintainable. So the centre clearly saying that if there isn't unity in terms of the states, the matter will not be maintainable in a court of law. As far as the Supreme Court is concerned, the Chief Justice of India, Justice D.Y. Chandrachud, is saying that the nature of the preliminary objection depends upon the canvas that they open up. We have to see what really they, as far as the canvas is concerned. Secondly, Justice D.Y. Chandrachud is also saying and asking is what really is the nature of the preliminary objection that is thought to be raised is your response to the merits, and they wish to hear them with regard to the response.
Now, because the Constitution bench hearings are streamed live, let's play it out for our viewers. This is what is happening as we speak in the Supreme Court. Let's start to it.
Whether, my lord, the court should wait for the legislature to act. Firstly, it arose, my lord, in Navtej. The court, my lord, entertained rather than waiting for the government to, my lord, remove it or not remove it. But there is, my lord, authority for the proposition. In, my lord, Navtej, Shaira Banu, Puttu Swami, that the court need not wait for legislative, my lord, interference. And if it is brought to the court's notice that my fundamental right is being restricted, my lord, by the state or by the society because of its mindset, which has to now open up, the court's duty is to act. That is, my lord, clearly laid down. My lord, our lives are passing by. We are getting older. We also want to have the respectability of a marriage, respectability of a couple. What is the point of saying that only criminality in your bedroom is removed? But, my lord, when you go out, there is a passage of Justice Chandrachud, my lord, in one of those judgments, that what matters is what happens in a public space. What is the concrete position? If today, my lord, what is the position? All right, 377 is gone. But if these people, call them queer, call them strange, people call them all different names. If they were to go to different places, people look at them. Look, they are going this way, they are going that way, they are doing this, they are doing that. That, my lord, that is a restriction or an infringement of my right, which is Article 21, to, my lord, live with dignity, freedom, privacy, full expression of thought under 19(1)(a), no discrimination under 14, and, my lord, in 15, as the lordship knows, there will be no discrimination only on the ground of sex, caste, creed, etc. And only on the ground of sex, lordship judgment, Justice Chandrachud. Talking about Nargesh Mirza, that Air India case, and, my lord, that Anuj Garg, that, my lord, the Delhi hotels case where, my lord, women could not, my lord, become employees. So your lordships have accepted Anuj Garg, which is an expensive definition of sex to mean sexual orientation. Sex does not mean, my lord, only male, female. And your lordships have, my lord, discounted the verdict in Nargesh, clearly. So Anuj Garg has been accepted by His Lordship Justice Chandrachud in that judgment, and also, my lord, in Nalsa, where we deal with transgenders. There are passage after passage that if you have to give them equality, that equality, my lord, also must reflect positively. So you have the negative part, don't discriminate. There is a positive part in 14 and 15, affirmative action also. My lord, sorry to say that Nalsa said that give them reservation. Years ago, nothing is done. Years ago. Your lordship judgment, my lord, in Navtej, gave full publicity. Today I read in the Indian Express. Today.
That is what is happening as we speak. Riveting arguments being made from all sides. Nilashish, sum it up.
Court has in fact decided to go ahead and hear the matter on merits. It has in a way declined the centre's plea that first the maintainability should be decided. The Supreme Court through CJI, as you understood, has said that we will go into a broader prospect. Please trust us. The Supreme Court has now begun hearing the case on merits, as you heard on your screen also from the Supreme Court, which is live streaming the case. Solicitor Tushar Mehta had earlier argued for the centre that the Supreme Court cannot adjudicate on the issue of on this particular issue on merits based on maintainability. However, it has been stated that generations later, people must not say that we do not bring the issue to the attention of the court, that every state has separate rules regarding marriage. States' views must be taken into account. This is what the centre said, saying that this was the domain of the parliament, and the parliament is the appropriate forum to hear this. But
by the looks of it, this looks like something which will go on for some time now, because so much to be covered from by all sides. Nilashish, thanks for your inputs. We'll keep